Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Please excuse the crappy lighting behind us. It's not often I actually get to shoot videos in the middle of the afternoon, but as you know, we have huge news out of the United States Supreme Court today in the matter of Cargill v. Garland, which of course was a challenge to ATF's ban on bump stocks. Now, I'm always late to the party. I know everyone else out here in the YouTuberverse has probably already got their videos out. I have had an opportunity to get through and geek out on the opinion itself, but I was stuck in court this morning and I had an opportunity to reflect on what I wanted to look for in the opinion to see if this was a very broad opinion or a very narrow opinion. And this had the chance to be a really, really big ruling. And don't take anything away from this. This is a big, big win for Second Amendment advocates nationwide. But is it as big of a ruling as you might think? Not so much. And I'll explain why here in a few moments. So today, let's geek out on the ruling and let's talk about bump stock ban struck down, but how big of a deal is it? Okay, before we get going too far down the road we're going down, we tell you here at Washington Gun Law all the time that we're not going to tell you how to think, but we are going to give you all the stuff to think about. Well, does the news treat you that way? And that's why I've been using Ground News, because in today's world of media bias and censorship, Ground News gives you the freedom to learn for yourself, to attach your own weight to the facts, and come to your own conclusion. Wow, what a concept, huh? Here's how it works. You take today's news story, for example. You start searching it out, and now, 1, you can see who the news source is and what is their political leaning. 2, you can actually learn who owns each news source. 3, you can see the headline manipulation to see how the story is being distorted. And most importantly, you can see the biased distribution of each story. But there's a lot more, and it's all cool. Take, for example, the blind spot. I love this feature. Now, it's only fully unlocked if you get a Vantage plan, but this allows you to see news stories that are only being covered by one side of the political spectrum. It really helps you understand the other side. Now, here's the best news. If you subscribe today at ground.news/Washington, you're going to receive 40% off the Vantage plan. Listen, it's time for you to break free from media manipulation. It's time for you to be able to make up your own mind. It's time for the news to start treating you like an adult. For more information, visit my good friends at ground.news/Washington. Okay, America, this is what we're talking about. We're talking about the case of Cargill v. Garland. Just came out today from the United States Supreme Court. It is a 6-3 decision in favor of the plaintiff Garland, which upholds the Fifth Circuit's decision, which threw this rulemaking order out. A majority opinion has been authored by Justice Thomas. There's a concurring opinion that we're also going to talk about. Haven't had a chance to get through the minority opinion yet. Don't really care today. I will probably get through that sometime over the weekend. Now, if you thought that this was going to be a huge, very broad ruling that would have sweeping implications for the advancement of what is supposed to be your inalienable rights, wrong. It is not that. It is a very, very narrow ruling. As a matter of fact, the majority opinion is only 19 pages long. For a Supreme Court opinion to be merely 19 pages long, that is really moving at legal light speed. All right, now, we're going to briefly review what the court had to say in a nutshell. But when I said this was a narrow ruling, it really comes down to this. This ruling was really just under statutory interpretation. Okay, it's really as simple as, well, this is how the court put it. Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. This case asks whether a bump stock, an accessory for semi-automatic rifle that allows the shooter to rapidly re-engage the trigger and therefore achieve a higher rate of fire, converts the rifle into a machine gun. We hold that it does not, and therefore affirm. And like I say, it's a very narrow ruling because, well, the court had a very narrowly tailored inquiry here, as Justice Thomas put it. The question in this case is whether a bump stock transforms a semi-automatic rifle into a machine gun as defined by Section 5845B. And of course, he's referring to 26 United States Code Section 5845, which has the machine gun definition in it. So you can see when you have a very narrowly tailored inquiry, you're likely going to end up with a very narrowly written opinion. Now, as I mentioned, this thing comes down to simple statutory interpretation. What does the statute say, and therefore what does the statute mean? As Justice Thomas wrote, a semi-automatic rifle equipped with a bump stock does not fire more than one shot by a single function of the trigger. With or without a bump stock, a shooter must release and reset the trigger between every shot. And any subsequent shot fired after the trigger has been released and reset is the result of a separate and distinct function of the trigger. All that a bump stock does is accelerate the rate of fire by causing these distinct functions of the trigger to occur in rapid succession. And with that, the court comes to this ultimate and pretty obvious conclusion. Nothing changes when a semi-automatic rifle is equipped with a bump stock. The firing cycle remains the same. Now, the court came up with yet another reason for which this rulemaking order was unconstitutional. However, here's the big thing. It's still rooted in statutory interpretation. As the court themselves stated, a bump stock is not a machine gun for another reason. Even if a semi-automatic rifle with a bump stock could fire more than one shot by a single function of the trigger, it would not do so automatically. Section 5845B asks whether a weapon shoots automatically more than one shot by a single function of the trigger. The statute thus specifies the precise action that must automatically cause a weapon to fire more than one shot, a single function of the trigger. Now, apparently the dissenting opinion, the minority, the three-judge minority, you know which three those are, said that, hey, listen, if you adopt this interpretation, you make 26 U.S.C. Section 5845 completely useless because it would allow people to circumvent the law. Justice Thomas was quick to point out, interpreting Section 5845B to exclude semi-automatic rifles equipped with bump stocks comes nowhere close to making it useless. Under our reading, Section 5845B still regulates all traditional machine guns. The fact that it does not capture other weapons capable of a high rate of fire plainly does not render the law useless. Okay, so in a nutshell, that is the ruling of the court. It is one really of strict statutory interpretation. But this is what I want you to be aware of, America, because again, I don't want to rain on the parade. Between yesterday's ruling on the pistol-based rule and today's ruling on the bump stock ban, it's been a good 48 hours. Let's enjoy it over the weekend. But here's what I want you to be, especially depending on what state you live in, okay? Number one, does this mean that bump stock bans are unconstitutional? No, it doesn't. What it means is that this bump stock ban is unconstitutional. There are other ways to, in fact, ban bump stocks, and there could be constitutional challenges to them, but they may be much more difficult. Take, for example, if Congress just amended the statute, okay? And as Justice Alito pointed out in his concurring opinion, there is a simple remedy for the disparate treatment of bump stocks and machine guns. Congress can amend the law, and perhaps would have done so already if ATF had stuck with its earlier interpretation. Now that the situation is clear, Congress can act. And so if ever there was the political will in D.C. to revamp the definition of machine gun and amend that statute, then you could easily capture bump stocks as well as force reset triggers, wide open triggers, and a lot of other devices. So this just simply says that this particular bump stock ban under this statutory scheme exceeded its scope. Okay, the second thing is, if you live in a state where you have bump stock bans, does that render these unconstitutional? The answer to that question is in all likelihood probably not, and here's why. Number one, your ban was probably passed through your state legislature, not some administrative agency in your state just rewriting a rule and suddenly turning a bunch of people into criminals overnight. So the implementation in and of itself is much more proper. Secondly, you may be operating on an entirely different definition of what constitutes an automatic weapon or a machine gun. Washington State, for example, here in the People's Republic of Washington, we define it based upon rate of fire. So even before we actually came out and banned bump stocks by name, I believe that they were probably already banned because they increased the rate of fire to such a point that it would have been prohibited under Washington law. Could an individual challenge the constitutionality of that? They could try, certainly, but the manner in which the law was implemented is still proper because it was done through representative government. And so finally, does this mean that bump stocks can never, ever, ever be banned as long as we live? No, a couple things can happen. Number one, you could have the political will in Washington, D.C. to rewrite the laws such that it would make them unlawful. Number two, you could have a political shift in the Supreme Court where suddenly there is not a conservative majority. And I got news for you folks. If that ever happens, you're going to lose a lot more than your ability to get bump stocks. Okay, the case once again is Cargill v. Garland. It came out just today from the United States Supreme Court. We're going to link up the order of the court down below so that you can geek out on it for yourself. Maybe you got ideas for videos we should be doing here at Washington Gun Law. If you do, you click on that link right there and you let us know, because some of the best ideas we ever had, candidly, weren't really our ideas to begin with. If you got any questions about this or anything else related to what's left of our Second Amendment rights, all of our contact information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.